We're recording.
All right, thank you. Good afternoon. The Appellate Court for the State of Connecticut is back in session. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counselor advised that to the extent that there is statutorily protected parties and or information here, that you should take extra care to not to reveal said information. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant and counsel for the applicant. Is there any feedback? I'm hearing a little bit. Perhaps some adjustments can be made. But in any event, all right. Let's begin, and perhaps if all parties can mute themselves unless you are speaking. Right there, you go. All right, thank you. I am Judge Elgo.
Judge Alexander.
Good afternoon, Judge DiPentima.
Good afternoon, Your Honors. My name is Kara Moreau, and I represent the appellant, Jared Charles, in this case. I represented Mr. Charles along with appointed counsel Richard Reeve, who was not present, obviously, for the technical reasons.
Thank you.
And I am Mitchell Brody, an Assistant State's Attorney from the Appellate Bureau, and I represent the state of Connecticut.
Thank you very much. For the record, I note that I can hear and see everyone. Please let us know if in the course of your argument you are experiencing any difficulties hearing or seeing the participants. If you should lose your audio or video capability, please log out and retry the Teams link which you were sent for this proceeding, and we will then take a pause. All participants must keep their video on and remain in view out of respect of for the process and the participants. All participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question to avoid talking over whoever is speaking, but will interrupt if for some reason you do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Alexander has kindly agreed to be our timekeeper this afternoon and will give you a 2-minute warning and also warning when your time is up. So this is the matter of Charles versus Commissioner, docket number 43643. We will begin and hear from the appellant.
Yes, Your Honor. Before I begin, may I reserve 5 minutes for a rebuttal?
Yes, you may.
I would also like to, before I begin, I may, and I mean no disrespect by this, but throughout my argument, as I did in the brief, I may refer to the decedent, Dennis Finial, and one of the witnesses, Jaquan Finial, by their first names, Dennis and Jaquan, just for ease of the court. But I certainly mean no disrespect by that.
Thank you for that clarification.
May it please the court. This is a case that from the onset cried out for self-defense. The basic foundational documents in this case should have led competent counsel to meaningfully consult with Mr. Charles about the viability and raising self-defense. As the discovery evidence in this case made very clear, at the time of the shooting, there were only 2 people standing together, Mr. Charles and Dennis, and they were engaged in a one-on-one, hand-to-hand confrontation. They were fighting. We know that Dennis had a gun. That was never in dispute. And as the 2 other eyewitnesses, Natasha Walker, an individual who had both a prior relationship with Dennis, but also a person who knew Mr. Charles. And so as Miss Walker and as Jaquan both told the police immediately after the shot was fired, Mr. Charles was seen running away with a gun in his hand. Now, this alone cried out for meaningful consultation with Mr. Charles about self-defense. Now, at the time of the shooting, Mr. Charles was young. He was 18 years old. He had been living in Hartford his whole life. He dropped out of high school in the 10th grade. And his statements to the police, although he admits at the habeas trial not entirely truthful, follow a clear progression. They progress towards the truth. And as I noted in the brief, when he first is arrested and speaking to the police, he denies all involvement. But after some time, he asks to speak with his mother. They tell him that people have told them that he had a gun. He gives a written statement. And in that written statement, Mr. Charles all but admits that he had a gun and that he shot Dennis. In that written statement, he describes an altercation over the cell phone. He describes having to grab Dennis's arm to prevent himself from being shot after Dennis pulled a revolver on him. He describes feeling cornered in, having to handle the situation the best he could. He says he was hurting because he didn't want to see Dennis dead. Dennis was a friend of his. But most importantly, he ends his statement by saying, "I couldn't believe it. This all happened so fast." But trial counsel, instead of consulting with Mr. Charles about these statements and the statements from the two others who put a gun in Mr. Charles's hand, and discussing the possibility, the viability of a self-defense claim in this case, trial counsel decided on his own, without consulting with Mr. Charles, that a third-party culpability defense was the best option in this case. And trial counsel decided this despite the fact that he would have to discredit both Jaquan and Natasha Walker, who both put a gun in Mr. Charles's hand, despite the fact that nobody, including Mr. Charles, put a gun in Jaquan's hand, and despite the fact that the third-party accidental shooting left so many questions. For instance,
Counsel?
yes, I'm sorry,
Judge DiPentima.
Yes.
I
just had a question.
yes.
Can you
I
hear me?
apologize. Yes, I apologize. I don't see the hands though.
I went like that. Here's my hand.
Oh,
Okay, my
I apologize.
question is, wasn't there testimony that Jaquan had a gun in his hand?
no, Your Honor. At the trial, Jared Charles testified that he believed that it was likely that Jaquan had a gun. He testified that based off of his knowledge of Jaquan, his knowledge of Jaquan and both Dennis, that he believed it was likely that Jaquan did have a gun, but he specifically testified that he did not see Jaquan with a gun and that he never saw that firearm.
What, just shifting gears slightly, what was the testimony at the habeas trial about the trial counsel's knowledge of the fact that the self-defense claim was so, what you're saying was so strong?
Well, at the habeas trial counsel maintained that self-defense wasn't a defense in this case. In fact, I believe his exact testimony at the habeas trial was it didn't exist. Trial counsel's opinion, even at the habeas trial, was that a self-defense claim did not exist because Mr. Charles failed to admit essentially to the police in any of his statements, and I say his statements in his one written statement or his two verbal statements, that he indeed had a gun and shot Dennis. And so trial
I'm sorry, counsel, but wasn't there testimony from the habeas counsel that he doesn't remember Mr. Charles even raising self-defense as a possibility? Am I wrong about that?
No, you are right, Your Honor. He testified. He said he didn't recall. He unfortunately didn't have any of his notes from the representation, and he didn't recall whether or not Mr. Charles had told him that he had a gun or acted in self-defense. But later in the habeas, oh, I'm sorry, Your Honor.
Well, I was just going to say, so the habeas court had your client's testimony about self-defense, and you're arguing that the evidence that trial counsel had before him, the discovery material he admitted knowing about, should have told him there was a self-defense here.
Yes, Your Honor. We certainly do maintain that Mr. Charles did tell his trial counsel that he had a gun, that he shot.
But the court didn't believe that. Habeas court didn't believe that, right?
The habeas court, it's not entirely clear. It does appear that the habeas court did not credit Mr. Charles's testimony. However, this court does not have to find, and that's part of our argument, this court does not have to find that Mr. Charles indeed told his trial counsel that he had a gun and that he shot Dennis in self-defense. Because, of course, our argument is that the evidence beyond any statements that Mr. Charles may or may not have made to trial counsel put a trial counsel on notice and required meaningful consultation with Mr. Charles. We certainly know trial counsel testified at the habeas that he did not have a conversation. He recalled that the first time he had a conversation about self-defense with Mr. Charles was indeed when the trial judge instructed him to. I believe trial counsel stated that the judge made him. But this conversation was in the context of a self-defense jury instruction. And of course, by the time that this conversation occurred, Mr. Charles had already testified, the state's evidence had already been put on, the defense had already been put on. And so our position is, at that point, this conversation about self-defense was a little too late. And indeed, the evidence that trial counsel had in discovery cried out for meaningful consultation with Mr. Charles. Beyond Mr. Charles's statement, which I described earlier, which talks about feeling cornered in and wishing that it didn't happen, there were the voluntary statement of Jaquan. And Jaquan describes an argument over a cell phone between Mr. Charles and Dennis. He describes Dennis's raised fist right before a shot went off. Jaquan subsequently gave an oral interview with the police after he had received immunity. And indeed, at that point, he admits that that after the shot was fired, he ran up to his cousin Dennis and he took Dennis's gun, and then he chased after Mr. Charles and fired 5 rounds at Mr. Charles. And what we know from this important statement is that Dennis's gun was out. At the time of the shooting, Jaquan doesn't describe fishing through Dennis's clothes for the gun. He says he ran up and took it. And so that critical statement certainly should have put trial counsel on notice that not only Dennis had a gun, but he had a gun out and aimed at Mr. Charles. And beyond just those 2 statements, we have the voluntary statement from Natasha Walker. Trial counsel had this statement early on in the discovery process. This statement, unlike Jaquan, who trial counsel describes the biases in terms of Jaquan is Dennis's cousin, Jaquan was involved, and indeed Jaquan was trial counsel's third-party culpability, the person he pointed to. Natasha Walker was much different. She had a prior relationship with Dennis, but she also had a prior relationship with Mr. Charles. They grew up together, they knew each other in the neighborhood, and she describes seeing Dennis and Charles walk down together. She describes a shot going off, Jaquan being on a bicycle at the end of the driveway, never leaving that bicycle. She never puts a gun in Jaquan's hand, but she puts a gun in Mr. Charles's hand. And that alone, in combination with the other statements, should have prompted trial counsel, put an obligation on trial counsel to have this meaningful consultation, this conversation with Mr. Charles about self-defense. And another thing that trial counsel had was the ballistics, the firearm evidence in this case. Because we know that, or trial counsel knew that the bullet that killed Dennis was not fired from the gun that Dennis had, the gun that Jaquan then eventually took and fired at Mr. Charles. And so in the very least, trial counsel was aware that there was a second gun. And certainly based off of all of the evidence in this case, trial counsel had a responsibility to investigate the circumstances of the case and to counsel Mr. Charles about viable defenses. And we submit that trial counsel's failure to consult with Mr. Charles regarding the viability of self-defense was a failure to investigate it as a potential defense. Now, in our briefs, we point to two rules of the Connecticut Rules of Professional Conduct, which we believe are important and particularly relevant for this case. The first is Connecticut Rule of Professional Conduct 1.4, which places an obligation on counsel to consult with a client, to talk to a client about available defenses. But further, and most importantly in this case, is Connecticut Rule of Professional Conduct 1.2. Because as we noted in our brief, were counsel to meaningfully consult with Mr. Charles about self-defense, and were they to decide that this was a defense that they were going to pursue, Mr. Charles would have needed to plead guilty, or admit guilt at least, on two of the charges that were lodged against him, because he wasn't simply charged with murder, he was also charged with two different gun counts. And so in order for Mr. Charles to assert self-defense in this case, he would essentially be pleading guilty to those two gun charges. And that's something certainly that would have been Mr. Charles's decision to make, of course, after consultation with the lawyer. But it would have been his decision on which plea to enter. But as we discussed earlier, trial counsel admitted during the habeas trial that he did not investigate the viability of self-defense. Now,
Counsel, it seems to me that if the court had credited your client with, in fact, having had that conversation with Attorney Hussey, that you might have a stronger case with respect to the obligation to investigate and pursue that defense. But in the absence of that, doesn't, I guess I can't see why third-party culpability theory is not within the realm of a viable theory, given that the self-defense theory, in the absence of a finding that there was clear evidence of self-defense and or at least a conversation with Attorney Hussey, why the theory that was taken wasn't within the realm of effective representation.
Yes, Your Honor, and I think I would agree generally that yes, the choice of which defense to pursue is a strategic choice. But trial counsel's decision in this case to go with the third-party culpability claim and to reject self-defense can't be considered a trial tactic because it wasn't an informed. Oh, I'm sorry, Your Honor.
I just question whether or not he actually rejected self-defense if in fact it wasn't something that was clearly before the attorney. But perhaps you can address that on rebuttal. Okay.
Yes, Your Honor.
All right. You have 5 minutes, correct? You asked for 5, so.
Yes.
Can you hear? You can hear me, okay?
I can hear you, Your Honor, but I unfortunately can't see any of the hands, so I don't know. I'm sorry, I don't know.
I should clarify. The hands are not virtual hands; they are actual hands.
Oh, then I apologize, Your Honor.
That's okay. That's quite all right.
I don't see anybody.
Can you not see our faces?
I cannot, Your Honors.
Oh, I did not know that. That's important that we can see you. Is there a reason? Do you not have the capability of seeing us?
No, I do, Your Honor. I have the well, the little circles with your initials in them. It was my impression that you had simply turned your cameras off, and I certainly wasn't going to instruct you to turn them on.
Oh, I'm so sorry. Well,
And I was
perhaps.
holding up signs for the time, so you wouldn't have seen them. I apologize.
Oh, I can see you now, Your Honor.
You can. Can you
I
see
can see
all of
Judge
us?
Alexander.
Okay.
Okay. I
Is it
guess I
when we
should.
talk that you can see us?
I can, yes. Well, before, I couldn't see you even when you were talking.
Okay. Well,
I could certainly hear you.
I suppose perhaps what I can do is, and you can't see you can't see counsel either, right, Attorney Brody?
I cannot.
Well, at this point, perhaps if Attorney Brody can continue, I'd prefer that you can see everyone. But
Your Honor, this is Lori.
yes,
What if
Lori.
she clicks on the three
Yes.
buttons on top? The three dots?
Yeah, can you go to the very top of the toolbar up there?
And there should be the gallery part.
Yeah, that's a good idea. See, there's three dots where if you take your cursor and
Yes.
okay, click on that and
Yes.
see if if you click on that, there might be a gallery function. Do you see anything like that?
I don't, unfortunately.
Do you see a together mode? Do you have a drop down list? Do you click if you're clicking
I
on it?
do. Yes, it's show device settings, show meeting details, enter full screen or keypad.
Really? Okay.
I'm not sure. But I don't need to take up the additional time for it.
Okay, well, just let us know. I guess what we will do is that we'll continue on, but if there are questions by the panel when you're back on rebuttal, that we'll just interrupt you, okay?
I would appreciate that. Yes,
okay?
thank you.
And we will also give you a verbal warning with respect to your time, okay?
Thank you.
I apologize. I wish we had known that.
No, I apologize for not speaking up earlier.
It's okay. All right, Attorney Brody.
May it please the court. From the state's perspective or the commissioner's perspective, Attorney Hussey was, when he formulated tried to formulate his approach to the defense, assessed, as we all know, the various verbal and written statements of the parties. And he explicitly testified at the habeas trial that he rejected a self-defense claim. And he said he did that because, as the habeas court said, there were no real building blocks that he was presented with at the time. What was absent, and this is important, what was absent from the three accounts that the petitioner gave to the police was that he in fact had a gun, that in fact he felt his life was endangered, and that he felt that a deadly physical force was the way to respond to that danger. And I think it's important to, if you look at all of those, my friend here tries to portray these three accounts as somehow an 18-year-old in search of the truth. But really what we have here is a drug dealer and a felon giving a series of completely exculpatory accounts. And he changes those accounts, not sort of his own volition, but he changes those accounts after the first one when he denies all involvement. And the police officer says, well, you were there and you were outside of your car, and says, okay. Then he talks to mom. He gives another account. And then at that account, he attributes the shooting to fellows from uptown, and then he doesn't then switch to seeking the truth again. He has to be prodded, obviously, by the police officer, and these are all in the police reports, who says he says, well, there were 3 people at the scene, and you were one of them, and you're lying. Then he comes up with the final account, which essentially meshes with the third-party culpability account, in which he attributes the death of Dennis to sort of unknown shots. And I want to emphasize a couple of things. And so the absence of really the building blocks of a self-defense claim is something which Attorney Hussey would have understood, would have relied on, even assuming that the petitioner had told him about this 4th account, because this 4th account would have therefore been completely at odds with the prior 3 accounts. And the state's position is that essentially it would have portrayed the petitioner as it's a problem for both defenses. That's why I argued they were both weak defenses, but it's a particular problem for the self-defense claim. And it depicted the petitioner as really a liar. And I wanted to point out something really important, which is that counsel said that he felt cornered, but presumably somehow as an indicator that his life was threatened. But that only came out, he only said that in his trial testimony. Cornered is not in any of his police statements, and I think that's important. And so what you have then is, in order to raise a self-defense claim, you would have had to have had a 4th account, at least for self-defense, in which it would have had to have mirrored what he purportedly told Hussey at the habeas trial. I apologize. I indicated at one point in my brief that he didn't do that, but in fact he did. But I would assume that it would have been a very, very sort of risky endeavor. And I wanted to point out that at trial, the prosecution made hay out of the changing stories, and the petitioner admitted to lying to the first 2, literally admitted to lying. So Hussey had a real problem with both the self-defense and third-party culpability, because with respect to third-party culpability, although it meshed with the 3rd account, which is in his police statement, it was at odds with his first 2 accounts, which essentially completely exculpated him. And obviously the third-party, the 3rd account inculpated him as well. So I would argue that, and there's another thing I think, which I think we can assume, since Attorney Hussey read all those statements, there's something that's really kind of jives with the absence of the building blocks of the self-defense claim, which comes from Jaquan. So if you read Jaquan's statement, Jaquan describes the behavior of Dennis, who's the victim. And he says, he knew that Jaquan was watching from the end of the driveway, and he said, well, I knew there was going to be a fight. With one hand, I think he said with his left hand, he put it up to the petitioner's chest, and the other hand, he made a fist. So that, to me, is a sort of a very difficult starting point for Dennis actually posing a threat of deadly physical force to the petitioner, although later on the petitioner does say that Dennis drew out a gun, but there's a contradiction there, and I think that's incredibly important. And I think what's really interesting is if you look at the habeas testimony, at the habeas trial, and you look at habeas counsel's final argument at the habeas trial, counsel says, well, with respect to self-defense, maybe Hussey could have somehow convinced the jury that with the raised hand, Dennis actually had a gun at some juncture. Because don't forget, all we know from the various police reports, at least prior to trial, is that the gun was pointed downward. although he did, although the petitioner did say in his last statement that he did draw a gun. So I would argue what you have here is two weak defenses. And when you have two weak defenses, it's counsel's strategic choice which one to take. And I would argue that this really isn't this. And so my friend here says, well, look, all the cases that I've cited don't really address the question of an investigation. But really, this is not quite an investigative case. This is really sort of what is counsel going to use with the information that he actually does have. He's not trying to discover anything, unless you're saying that what he should have discovered is this fourth account, which he gave at the habeas trial. But counsel would have rejected that. And he said that because whatever that fourth account was, it was inconsistent with the prior accounts and was most consistent with the third-party culpability account. And that is a reasonable strategic decision that counsel can make. I wanted to sort of also say—
Attorney Brody, could I ask you a question, please, about what you just were discussing? And that is it your position that when it's self-defense, when the claim is a failure to investigate self-defense, that's somehow inherently different from another type of defense, because presumably you rely mostly on your client for the information you need to present that self-defense, or am I misreading where you're going?
Well, I'm not quite saying that, because I think my friend here is right that counsel doesn't have to end with what his client tells him. So it's tricky, but clearly counsel was aware of the limitations of his self-defense claim. And I think that's important. And Hussey said something at the habeas trial, which I think is also important, which he said, I believe this third account. He said, I believed him when he said he was engaged in a tussle over the gun and shots rang out. And that's something to take into consideration. After all, who is best placed than his attorney to assess his client's credibility, particularly if you weigh that third account with having to present, in fact, a fourth account. So I can't give you a complete answer to that. And I understand the jurisprudence, which says that, look, counsel is not expected to investigate things which he can't possibly know about. But this isn't really quite that case, because counsel was aware of the possibility of self-defense. He just didn't think it really was viable. And I think when he said it lacked the building blocks, I think that necessarily implicated all the prior police statements in which those building blocks really weren't created, and therefore he had to present this fourth account. And I would also argue something else, which is, and I think it's obvious, which is that a self-defense, look, really what the evidence shows is that the petitioner shot this guy. That's really, and that's the state's case. So, and that's the strongest evidence in this case. And that's the problem, which you have two weak defenses and a pretty good state's evidence. So, you know, Hussey had to sort of maneuver around that. And I think one of the things that's come up, which we've talked, which the briefs have kind of addressed, is this notion of what do we do with self-defense, in which it's a justification defense. And what that means is you have to admit guilt regarding the charges, which includes the gun charges. And what self-defense is, it says, well, I did it. I did it the way it's charged, but excuse me. Excuse me, I'm not subject to liability because it's self-defense. So it puts the gun in the petitioner's hand. And that, yes, Judge Elbow.
You know, it occurs to me, and maybe this is kind of a common sense, and maybe not, but it seems to me that if someone has a viable self-defense claim, and in fact that's what happens, is it not usually the first thing that one says is, I did it in self-defense? I mean, maybe I'm wrong. Maybe there's just all kinds of variables, but could that not really figure into how you weigh the strength of a self-defense case, or is it not?
Well, I can't really. I think that the panel has much more experience with this than I do, frankly, as judges and as advocates. So it's not clear that I can really, and I'm not in a position to really answer that. But one thing that occurred to me in reading the various police reports is that if really the petitioner felt his life was in danger, that would have been something which he would have said in his various statements to the police. Now, that's not a sort of a completely supportable argument. It just occurs to me as I was reading it, that is something that would have come to the fore. And it's only really at trial, much later on, that he says, I was cornered. Don't forget, this is his friend, and his friend takes out a gun, but we don't really know how threatened the petitioner was to the extent that he felt that his life was in danger. And that's the key to the self-defense claim. And the third party culpability defense, I would also want to point out to the court. So my friend says, well, the self-defense claim would have required the state to disprove self-defense beyond a reasonable doubt, and that would have made it sort of more appealing than the third-party culpability defense. But really, what is third-party culpability? Third-party culpability evidence is evidence which undermines identity, and the state has to prove identity beyond a reasonable doubt. So essentially, I don't see there really is much difference between the two, and really, in the end, the question of a gun charge would have been admitted with respect to self-defense, because you have to admit to everything, and the charge covers using a gun. And with respect to, it would have been really no difference with respect to third-party culpability, I don't think, because it's either complete denial or complete acquittal. With respect to the guns, I think it would be a wash. But I don't think, sort of in terms of proof, they're really any different. I just think that, Hussey was faced with a problem, which is that really the petitioner comes off as a liar, basically, as the prosecutor argued at the trial, and it really served him better to take the third-party culpability defense. And there are a couple of things I want to point. I'm not saying that the third-party culpability defense is a great defense. It also had problems. I would acknowledge, but let's remember that if you look at that defense, Jaquan says that the petitioner had a silver gun in his hand, but it's hard to figure out how that would actually work out. But if you actually look at trial, Jaquan on cross-examination backs off that and says, well, maybe on direct, he says, well, yes, it was a gun. And then on cross-examination, he says, well, maybe it could have been a cell phone. So, each defense had its pluses and minuses, I would argue. And the fact that the petitioner had to admit to the charges in order to raise a self-defense claim, I think, kind of pushes the balance over to the third-party culpability defense. I've cited a couple of cases. It's not clear to me whether my friend here disagrees with the notion that if the defenses are actually weak, that it's a strategic decision, and therefore it would have been up to Attorney Hussey. I think if I understand the claim is that the investigation was deficient, and really we don't have this weighing of two weak defenses. We really have a stronger self-defense claim, which the state believes is not actually accurate. It's not as if whether Hussey sort of elicited this from the defendant's lips or whether the defendant or the petitioner told him that, he had clearly rejected that defense because there wasn't a viable basis in the prior police reports. And those police reports, if the defendant then changed and gave a fourth story, and I believe I'm repeating myself, would have portrayed the defendant as even a greater presenter of apocryphal accounts. And I don't really think, unless there are other questions, I have anything else to add. So the state would rest on its brief.
All right, thank you very much, Attorney Brody. All right, Attorney Moreau, I was hoping that we might be able to get some IT assistance. Is it true that you still cannot see us? Oh, now we can't hear you, but you need to just unmute yourself.
I apologize. I can see you right now, Your Honor, but for some reason, as soon as I start talking, all I see is just the initials and the squares.
Okay, all right. Well, why don't you go ahead, and again, I would remind my colleagues that we just need to verbally interrupt and also verbally give Attorney Moreau her time. So thank you very much.
Thank you, Your Honor.
Go ahead.
I'd like to begin by getting into the question about whether this was simply a trial tactic, whether trial counsel simply disregarded self-defense as a trial tactic. And like I said, generally speaking, I would agree that the choice of defenses is a trial tactic. However, in order to disregard a defense, it needs to be investigated. And in this case, investigation into the viability of self-defense was critical for this investigation, was meaningful consultation with the client. And of course, different defenses may require different things, but as a baseline for self-defense, in order for trial counsel to investigate its viability, he needed to have a meaningful conversation with Mr. Charles. And I'd like to get back to the idea that Mr. Charles, and a drug dealer and a felon, should have been free to admit what he had done to the police. And I just think that's simply, well, it's just not what we see. Mr. Charles admitted, yes, he was selling drugs at that time, but he's still an 18-year-old kid living in Hartford with his mom. You can tell from his police interviews, at one point, he in fact asks to talk to his mom. He's scared. This happens often. We see it often in police statements that the first statement denies everything completely, and it inches closer and closer to the truth. And I think, moreover, what the requirement that trial counsel have a meaningful consultation with Mr. Charles, why that's so highlighted in this case, is because of the fact that Mr. Charles was an 18-year-old kid who's understandably terrified because he just shot someone, not just anybody, but his friend. And so meaningful consultation in this case would have given Mr. Charles an opportunity to explore, to determine whether he was going to tell the full truth on stand. It would have given him an opportunity to talk about self-defense with his lawyer, to talk about whether he should plead guilty or he should admit to the gun charges to assert self-defense. But none of that happened. None of that consultation happened. None of those discussions happened. And because of that, there was not a meaningful investigation into self-defense. There was not an investigation into its viability before it was simply rejected. Not to belabor the points, but this case truly called for self-defense based off of Natasha Walker's statements, Jaquan's statements putting a gun in Mr. Charles's hand, a one-on-one, hand-to-hand confrontation between these two individuals where one of them ends up shot. The discovery evidence did make... Oh.
You have 2 minutes. I'm just letting you know.
Thank you, Your Honor. The discovery evidence did make it clear. And despite any statements Mr. Charles may or may not have made, which this court does not need to find, trial counsel had an obligation to talk to Mr. Charles about the evidence that made clear that Dennis was armed, He was angry and the aggressor in this physical altercation. Given Mr. Charles's young age, the clear facts, the witness evidence, meaningful consultation was necessary, but that wasn't done. And because it wasn't done, Mr. Charles's right to effective assistance of counsel was violated. And because of that, we would ask that this court vacate the conviction and order a new trial. Thank you, Your Honors.
All right. Thank you, counsel, for both of your arguments and your patience with the technology. I can say thank you for participating in this virtual hearing, and I'm sure you, like all of us, are very much looking forward to when we're returning to our regular courtroom. But until then, we will be taking this matter under advisement, and we'll be recessing until 3 o'clock. All right. Thank you again.
Thank you.